Good morning, everyone. Welcome to Harry G. and Associates webinar on the H-1B lottery and Trump effects. Today, we're going to be talking a little bit about the basic H-1B lottery information in part one of the presentation. And in part two, we're going to be going into some specific challenges that we're seeing emerging under the new presidential administration and some strategies that we can employ to try to maximize our chances of success during the upcoming H-1B lottery.
Right, and Jim Seibert here will be presenting along with me, Duraj Suvarna. And just as a reminder, please note that all attendees are in talk or listen only mode rather. And if you have any questions, you could type them in the relevant questions box and we will get to them time permitting at the end of our presentation. Without further ado, let me get started with the H-1B lottery portion of the presentation. We separated it into two parts here, part one being the H-1B lottery and what it is about. So what is an H-1B? So the H-1B is a temporary work visa classification that's issued to foreign nationals who are in a specialty occupation. So the Immigration Service actually focuses on the eligibility requirements for the position being that it is professional. And what they mean by professional is that the position minimally requires a bachelor's degree. And as it would follow, the foreign national would also have to have the relevant bachelor's degree. Is there anything that you'd like to add to that, Jim, or go to the next one?
No, I think that's a great summary, but this is very important for some of the issues that we're going to be talking about in the second half of the presentation relating to specialty occupation.
Right. So the next question comes up, how many H-1Bs are issued in a given year? So the H-1Bs are limited to 65,000 slots for individuals with a bachelor's degree, and Congress has mandated an additional 20,000 slots for individuals who have a master's degree or higher from U.S. universities. Mm-hmm. Now, part of those numbers are reserved for Singaporean and Chilean nationals, which is the H-1B1 classification. That's at about 6,800. But any unused numbers from that 600 would flow down back to the H-1B nationals. Did you want to talk about how many?
Well, so I think, it's important to note that those who are eligible for the U.S. Masters cap, essentially the lottery is two parts. And so they have their own lottery at first for those 20,000 slots. And then individuals with U.S. Masters degrees who are not selected in that special master's degree lottery are then added to the pool for the remainder of the 65,000 slots that apply generally to everyone else. And the H-1B one, that's really a completely separate process. So while there are special numbers allocated to those, that's a classification that can be applied for directly at the consulate. There's not really a lottery process for that because in the past, there has not been the number of applicants to even use up all of the numbers. So if you have individuals from those treaty countries like Singapore and Chile, they may be able to obtain something similar to an H-1B during any time of the year.
Yes. Now, it's important to note that these numbers get used up very quickly. So last year, the Immigration Service received just shy of 200,000 applications, and this was within the first week of April?
Yeah, and I think the year before it was closer to 300,000, and so the demand is very high. And there's no guarantee that an individual who applies will be selected in the lottery, but because of the benefits of the H-1B classification, which we'll get into a little bit more during the presentation, it can be worthwhile to go ahead and file that application despite the odds that may be present.
Right, and it's also important to note that individuals with a master's degree, they get two shots at that, as Jim was mentioning previously. Bachelor's degree gets selected 65,000, and even masters also get selected from that pool, but then they have the separate 20,000 pool that the masters individuals with a U.S. master's degree can fall under. So Now that we've got what the basic, H-1B numbers are, the next question that comes up is how long are these H-1Bs good for? So the Immigration Service generally issues the H-1Bs for a maximum of 6 years, and they're issued in 3-year increments. So for the very first time, individuals would get a 3-year H-1B followed by a subsequent 3-year extension. Now, there is a possibility to reclaim certain time that the individual would have spent outside the US while on H-1 status, and the technical term is recapturing. And there are certain extensions that are available beyond the sixth year if the foreign national reaches certain milestones of their employment-based permanent resident process. Now, if the foreign national finds himself outside the US for 1 full year, they can always try to get another full set of 6-year quota. But in order to do that, they'd have to go through the lottery process again, meaning applying in April and getting put again in that list of 200,000 as it was last year.
Mm-hmm. Yeah, and that those extensions beyond the 6th year can be particularly important for individuals from China and India who face significant backlogs for the permanent residency process. And so that is one of the major advantages of the H-1B is that, it allows for dual intent. So the worker can be pursuing their permanent residency while also working as a non-immigrant for your company. But it also can be extended essentially indefinitely while their green card process is ongoing once you reach certain stages. So, for example, Indian nationals who may be facing, an over a 10-year backlog in some situations, that is absolutely essential and part of the reason for the demand.
Right. So now that you've got the H-1, what is permitted under the H-1B? So the H-1B is a company-specific and employee-specific sort of petition. So it restricts the individual to work for that petitioning employer, and it's only for that employee, so foreign national employee. So if the H-1B beneficiary, the foreign national who's received the H-1B, wants to work an additional or a side or a second job, they would need to get a second H-1B approved in order to work on that side job. And if within their company they get a promotion or they get some sort of career progression, you would still need to check back with the attorney to figure out if an amendment is possible or if we would need to file an H-1B change in position.
Mm-hmm. Yeah, and it's also important to kind of understand just the process. So the H-1B lottery that we're talking about is really for initial H-1B applications. And so individuals who haven't gone through the process before need to get selected and have been counted towards the H-1B cap or the numbers that are available during a given year. Once you've been selected and counted towards those numbers, you're able to retain your H-1B and move around to different employers. So, this is really a different process than, say, you have an individual who already has an H-1B and maybe they're wanting to switch to your company. And so it's really two different processes, and it's important to have that distinction.
Right. So if you made it in the cap once, you're essentially good for 6 years. And if you're applying for a side job or a promotion within, you have to file a change of sort of position. You don't have to go back in that lottery. You'll have to go back in that lottery only if you stay outside the US for 1 full year and you want to try and take advantage of 6 years again. That's when you go into the lottery again. So all this talk about cap, H-cap, and the lottery brings us to, when is the most opportune time, or when is the ideal time to file for the H-1B. So the fiscal year of the government begins of the H-1Bs begin on October 1st. So the applications can be received by the Immigration Service about no more than 6 months prior to that date. So the lottery is typically held on April 1st, or rather the first 5 business days in April. So that's the earliest you can file. And for the last however long I can remember, 3-5 years, we've been promoting or asking our employers to file the H-1Bs as early as possible, being the first day of April, the first business day of April.
So typically, the way that the government has operated this in the past is that during that first 5 business days, they'll collect all of the H-1B applications that are submitted during that window, and at the end of that time period, they'll announce that the cap amount has been met, or that they've received more applications and there are slots available. And from that pool, they'll say that we're not going to accept any additional applications, and then conduct the lottery based on those have been individuals who applied during that 5 days.
Right. So let's just go over the typical steps involved in applying for the H-1B. We start off gathering information from the employers regarding the position, and we discuss, what the prevailing wage and actual wage would be for the position. And these are technical terms, prevailing and actual wages, that we will get to in the coming slides. But we go over that with the employer based on the job description. Once we're satisfied with that description and the wage level, we then file a labor condition application, an LCA, with the Department of Labor. The Department of Labor takes about 5 to 7 business days to certify these LCAs. And once that is certified, we can then file the H-1B, the I-129 petition, which will have original signatures from the employer. And we submit that to the U.S. Immigration Service. And then typically the Immigration Service takes, I guess, about 2-3 months for the HCAP lottery cases to send us receipt notices. And once we get the receipt notice, it is then either waiting for, it means that you've been selected in the cap, first off. And from there on, we are either waiting for an adjudication, which can be an approval, or the government asking for additional evidence in order for them to approve the application. Now, once you get that coveted H-1B approval, if you're outside the US, that is when you apply for the H-1B visa at the consulates to come back into the US. But if you're already in the US, then you would switch your status to the H-1B on October 1st.
Mm-hmm. Yeah, and I think the big takeaway from this slide is that there are a number of prerequisite steps to, getting that H-1B petition ready. Depending on the wage offered by the employer, there may need to be some back and forth about what exactly the type of position that is offered, what that needs to entail, so that we can come up with a situation where the wage level is acceptable to the employer. And also there needs to be lead time to get that LCA submitted and approved by the Department of Labor. And that process can be drawn out even longer if there hasn't been an H-1B filed by the company previously, because the Department of Labor will actually need to verify the existence of the company, and that can add several days to the process.
Right. So as we'll see further down this presentation, that there are certain complications that could arise, which is why it's imperative for the employers who are considering to file their H-1Bs to get into discussing with the attorneys about the position as early as possible. So as with any of the applications filed to the to any governmental body, there are certain obligations, and what the company's obligations are with the H-1B is to first ensure that the foreign national H-1B employee is paid a wage that is either equal to or higher than similarly situated employees in the same position. The employer has also got to file an LCA, file and post the LCA in certain locations of the work site itself. They've got to demonstrate their ability to pay the salaries of the foreign national. And they've also got to assert to the government that they have any licensing requirements that might be needed under the Export Administration Regulations or the International Traffic in Arms Regulations. The company is also obligated to maintain a public access file that's per the Department of Labor's compliance requirements. And if the company terminates the individual during the H-1B period, they are responsible for providing reasonable cost of return transportation for that foreign national H-1B employee. Yep. So going on, let's talk about the prevailing wage, which is one of the things that the employer is obligated to pay the foreign national. So there are two different wages as such that comes into play here. One is what is called an actual wage, which is what similarly situated employees in the same position are getting paid. The H-1B foreign national employee would also need to be paid that wage. And then there is another prevailing wage that is mandated by the Department of Labor, and that is called the prevailing wage, which is in the Department of Labor's.
They take statistical samples of specific geographic areas and compile wage data for a specific occupation. So essentially, it's what the Department of Labor believes any specific job needs to be paid.
Right. So the foreign national would need to be paid either the actual wage or the prevailing wage, whichever is higher. So that's the way they document wage level compliance. So again, we briefly got into what the prevailing wage was. It is something that's statistics that's taken by the Department of Labor and the BLS, which is the Bureau of Labor Statistics. They collect wage data annually for certain positions, and they've got 4 different levels, which is your level 1, which would be an entry level, a position that requires just a bachelor's degree, or anything more than that would increase wage levels in one step increments, and it can go as high as level 4, which is the highest as documented by the Department of Labor.
Yeah, and this is really what a lot of the job description discussion at the outset is going to pertain to, because most employers, they don't write job descriptions specifically for immigration purposes. So a lot of times things are couched in terms of preferred requirements, like what would you want from the ideal candidate who applies for a position, where the government is really asking about minimum requirements. What is the minimum amount of experience that's necessary for someone to do this job? And that's what's going to determine the prevailing wage. And so those are things that may need to be sorted through so that we can determine what the company actually needs to offer this individual in order to comply with its obligations, which Jiraj just discussed, and make sure that it's not exposing itself to potential fines and back wage liability.
Right. So here's an example of what a prevailing wage is with specific to a job, the job title of computer systems analyst. And also in these 2 pictures, both on the left and the right, you'll see there are 4 wage levels, essentially level 1 wage, level 2 wage, going up to level 4 wage. So a level 1 wage would be a position that requires just a bachelor's degree. And as we mentioned previously, it depends on geographical location. So for our example, we've taken the location of the greater Houston area, which is Houston, Sugar Land, Baytown in Texas. And so you can see in 2012, 2013, the level 1 wage was for a computer systems analyst was just under $54,500. Now, be it for inflation or the availability of positions or the dearth of employees in that specific category, the wage levels could go up or down. So in this case, on the example on the right, you'd see 2015, 2016, the wage levels have gone up. As you can see, the entry level position for a computer system analyst would be 62,566, which has gone up by over 10,000 in that 3-year time frame.
Yeah, and I think that this is really important to understand. One, because it can come into play during future extensions, but also frequently we have employers asking us for individuals who are maybe on a different classification like TN or STEM OPT, who eventually would want to move over to the H-1B classification. When should we apply? And we typically recommend, because of the nature of the lottery process, that you do it as early as possible, because it may take multiple attempts for an individual to be selected. but it's also beneficial frequently for the employer to apply earlier rather than later because the wages, not always, but generally speaking, go up. And so the longer that you wait, the more that you may be required to pay that employee. And when we submit that LCA to the Department of Labor, you're essentially locking in the current wage rate for 3 years. So
That is correct.
That is, something that, can be to the employer's benefit if they start the process earlier.
Right. So filing that LCA, you can file an LCA for a maximum of 3 years, and filing it for 3 years will lock in the salary, will fix in the salary that the foreign national needs to be paid for that 3-year limit, three-year period, notwithstanding any rises in that particular job classification or downturns in the economy, which would lead to the salary going down. So now we've got to discuss if there are any special considerations for students. So students, while they're on F1 status, typically you'll see a student graduating in May and December, right? So around that time, so the earliest a student can file for the H1 would be April 1st. So typically students see a gap in their work classification or work authorization because they graduate on a particular date, which might be way before the October 1st date. So students have an ability where if they file the H-1B on April 1st, that would help them, if they get the receipt notice in time, that would cover their employment continuity up until October 1st, so long as they get selected in the CAP.
Yeah, and I think that that's really, really key because the individual to take advantage of this extra work authorization that's available, they need to be in valid student status on April 1st. But if they are, or if they're within the 60-day grace period, which also qualifies, they may be able to continue to extend their ability to stay and to work through October 1st, even though their student status would be ending otherwise. Right.
So it's with the cap gap provision, it's important to note that it's only valid until October 1st. And that's imperative because sometimes we see the immigration taking longer to approve some H-1B applications or petitions that are filed with them. So if the H-1 is going to get approved sometime in November, the foreign national would need to stop working for that company on October 1st, but he can remain in the US until that application is adjudicated and then begin working for the petitioning employer. So now we've talked about students, and let's talk about family members. So dependents of H-1B, typically spouses and children, are eligible for H-4 visas so long as their principal spouse has and maintains the H-1B. What's important on the H-4 is also that time spent on that status is not counted. So if an H-4 spouse decides to go and get their own H-1B, their 6-year clock would start from then. Any time spent on the H-4 status does not count towards that. But they would have to go through the lottery process again. H-4s are permitted to study and attend school in the US while on H-4 classification, but they have got to remember, the H-4s have got to remember that they have got to maintain their individual status and file for extensions along with their spouse, as it's not automatically conferred on them. So if your H-1B spouse gets a H-1 extension, that extension does not automatically transfer to the H-4 spouse. They've got to file their own independent extension applications. H-4s are not permitted to work for the most part, with the only exception that if the H-1B spouse gets into a certain point of their employment-based permanent resident process, the H-4 spouse can apply for employment authorization. So let's talk about the application fees involved with the H-1Bs. The petition itself for the H-1B, which is the I-129 petition, is $460. Dependents, the 539 would be $370. These are all government filing fees, the fees that you need to pay to the government if you're filing for these applications. Now, the employers are responsible for the training fees, which is $1,500, which is another fee that's given to the government as part of the H-1 filing fees. And it's $1,500 if the company has 26 or more employees. If they have 25 or less, then that fee would come down to $750. There's also a fraud fee that's given to the that's paid to the immigration service, which is $500, and the fraud fee is paid just once per company per employee. And the $1,500 or the training fee is paid twice for the initial petition and the first extension. Thereafter, the $1,500 and the $500 fees will not need to be paid. There is an ability to request expedited processing, which is known as premium processing, where you can get a decision within 15 calendar days, and the government charges an additional $1,225 for that service. Now, there are certain employers that are H-1 or L-1 dependent, and if they have 50 or more employees and more than 50% of those employees are either an H or L status, those employers would need to pay a $4,000 additional fee. Apart from all of these fees, there are also attorney fees, which the attorneys charge as a service to put together the applications. As can be seen, it's getting more and more complicated, so there's more and more involvement with these sort of applications.
Yeah, and I think it's important to note that if you're filing in the H-1B lottery, the employer needs to pay these government fees, but if the individual is not selected, the government won't cash those checks, and so those fees would be returned to the employer. However, the legal fees, those are earned by the attorneys by virtue of preparing and submitting the application. So, there can be some, money that is recouped if the individual is not selected in the lottery. It's also important to note that, the employer can have the employee pay some of these fees in certain situations. The training fee is required to be paid by the employer regardless, but other fees can be paid by the employee, provided that the amount paid by the employee would not bring them below the prevailing wage amount. So there are options there that can be discussed depending on the financial circumstances.
Right, and there are certain technicalities with splitting the fees between the employer and the employee. So it's always important to have that discussion with the attorney. Mm-hmm. Now, the premium processing, although you get a decision within 15 calendar days, as far as the H-cap is concerned, it does not guarantee you a spot or does not guarantee you being selected in the lottery.
It also doesn't allow you to begin working before October 1st. Essentially, this is a way to get an approval faster, and that can be useful in a couple of situations. One, if the individual needs to travel. Typically, if you travel while your change of status is pending, that can result in the change of status being abandoned, meaning the individual needs to go to the consulate and apply for a visa. So if you know there's an upcoming trip, it may be worth it to premium process and go ahead and get that final decision. It can also be useful for planning purposes. Say you have a student who's on OPT and it's going to run out. You may just need to decide what your plans for your business are. And so by filing under premium processing, you can, discern whether or not the case is going to be approved or denied, and that may help you just with the planning process.
And in theory, you could be notified being selected under the lottery quicker and faster than the regular processed applications, mm-hmm. because premium processing usually sends out email receipt notices ahead of time, mm-hmm. if you're selected in the lottery. So if you think, for planning purposes, as Jim mentioned, if you think that you're going to be selected in the, or if you need to be sure that you're going to be selected in the lottery, it might be worth the $1,200 premium that they charge for the expedite but it's definitely an optional expense, so it's something that you would need to consider. So I think with that, we come to an end of the basics of the H-1B. So let's move to part 2, which is the Trump effects.
Okay, great. So as probably most of you are aware, President Trump campaigned on tougher immigration policies. And so we're definitely seeing that carry over into the H-1B classification. And we want to talk a little bit about, kind of the reasoning behind what the administration is doing, as well as the issues that are coming up and strategies to overcome, some of the problems that can be encountered. So the first thing is really background, but I think it's important for understanding. Last year, when we were preparing for the H-1B cap, the administration released this a new memo or policy guidance rescinding prior government interpretations. So essentially what had happened was in the early 2000s, the Bush administration had issued policy guidance saying that computer programmers, even though the positions may not require a bachelor's degree because a lot of these skills were learned through maybe during the course of hands-on training or through an associate's program or something like this, they should still be considered specialty occupations for purposes of the H-1B. And this memo that the Trump administration released took back that guidance and said, well, actually, we shouldn't just be assuming that these positions are specialty occupations and that the officers who are adjudicating the cases should look at these more closely, and that they should also look at the wage level that's assigned to it, and that entry-level positions for computer programmers are maybe not rising to the level of a specialty occupation or one that requires a bachelor's degree. And so this kind of came out and there was some attention paid to it, but I don't think that everyone fully realized the ramifications that were going to come from that. But so this is kind of how it all started.
Right. So it actually went it went to the core of the matter because especially for the IT industry, when individuals were classified as computer programmers, by saying that a computer science degree is not exactly a specialty, or a computer programmer is not exactly a specialty occupation, they were saying that the position itself was inherently not eligible for the H-1B. So they were attacking the computer programmer industry in a way by not acknowledging that it was actually a professional occupation.
Yeah, and I think a lot of it comes down to politics. During the early 2000s, this was, an industry that was trying to be promoted, and they were attempting to make the H-1B available to meet job shortage needs and things like this. Now, in the years following this guidance, there has been a lot of criticism of the IT industry, particularly under accusations of visa abuse and things like this. And so now we're seeing kind of, again, political ramifications where there's some, questions being raised about whether or not these individuals should qualify for this visa program. This segues nicely into kind of the next slide, which deals with Buy American and Hire American. So shortly after this memo came out, President Trump issued an executive order that contained a lot of information about promoting U.S. jobs. And in that executive order, it specifically spoke to U.S. immigration policy and saying that one of the goals of the immigration system is to promote higher wages and employment rates for U.S. workers. And so the inference from that is that there should be more scrutiny of visa applications that would go to foreign nationals because the inference is that those visa applications may be undercutting jobs and wages for U.S. workers.
Right. So computer programmers filing for the H-1B, H-cap, or even H extensions nowadays need to be concerned, especially if they're going to be falling under that entry-level wage requirement, because the current administration is, I feel at least, is specifically targeting the IT industry and trying to hire more US workers in that particular field, as they have identified it as a potential where there are mostly foreign national workers.
Yeah, no, I mean, it's undeniable the level of scrutiny has gone up. As you can see from some of the statistics that USCIS has published during the past year for H-1Bs, the RFE rate has gone up 45%. And so that's evidence that the government is looking much more closely at these applications. The government hasn't released official data on the H-1B denial rates for the past year's H-1B lottery, but anecdotal information suggests that there's been a substantial increase in the number of denials, which directly, in my mind, correlates to the increase in RFEs. The government is looking for reasons to deny these cases, and frequently they're raising new arguments that or arguments in new ways that we haven't previously encountered. And so it's important to strategize for these issues as we're planning for the next year's H-1B lottery. So what specific issues is the government raising? Well, most of the RFEs that we saw for these H-1B petitions were targeted entry-level positions. And it's important to note that while I think that the genesis of this was really with the IT industry, in application, we saw it really spread beyond that to all types of positions. And so anything that had a level 1 or a level 2 wage was subject to scrutiny, and the government was also focusing on specialty occupation issues. So really kind of fell into two broad groups of RFEs. Specialty occupation, was this a position that really merits an H-1B based on the level of specialty that job requires? And then the other ones were RFEs pertaining to the wage level, and was it an entry level position that didn't have that certain amount of specialty, or were maybe the job duties inconsistent with the wage level that was assigned?
Right. The government started getting a little more creative in that they were approaching it differently by saying clearly qualified wages, like inherently qualifying occupations like engineers. They were saying you say this is an entry-level position, but your description suggests that the person would be managing or leading or may lead certain projects, which suggests that the position is not an entry level, but more a higher level with supervisory duties. Mm. So they started getting creative and trying to look for more ways to ask more questions on the H1.
Yes. So just to kind of delve into those issues a little bit more, the specialty occupation RFEs that we were seeing pertain primarily to the nature of the job. And some of the stuff that we were seeing was, even though the employer said the position required a bachelor's degree, they would go to certain other government sources like the Occupational Outlook Handbook and try to say that this job really fits into this job classification, maybe not even the one that the employer specified, and argue that that position is one that doesn't require a bachelor's degree. So that is something that we saw a fair amount of.
Right. As an example, we had a programming analyst who was dealing with green solutions. We classified the position, we being the employer and the attorney myself, classified the position as being a computer programmer or programming analyst. Mm. But the Immigration Service saw a lot of green and environmental issues and came back to us with an RFE saying, no, this position should not have been a computer programmer, but is an environmental engineer position. So they tend to bring up their own inferences and their own positions on depending on what the job description is.
Yeah, no, absolutely. I mean, I had a similar case with an architectural intern. Mm-hmm. That was a position that was for someone who graduated with a degree in architecture, but was waiting to actually receive their architecture license, which they couldn't do for a number of years until they had actually gained certain experience. But the government came back and was saying, well, actually, we don't think that this is an architectural drafter position, but rather this is a civil drafter, which is a different occupation that doesn't require a bachelor's degree. And so these are the kinds of issues that, the government is raising, trying to, raise questions about eligibility.
Right.
And,
so now more than ever, it's important for us to look at the job description and really have a discussion with the employer on including as many things as possible, as many items, as many hot buzzwords as possible in the application.
Yeah, no, absolutely. I mean, and we'll talk about this a little bit more as we move through this part of the presentation, but one of the keys is going to be drafting a job description that is designed for immigration success. If you're just using a cookie cutter job description with the kind of scrutiny that the government is putting on these positions, you're likely going to run into certain pitfalls. And so there needs to be a certain amount of advanced planning with these issues in mind. The other specialty occupation issue that we're seeing is pertaining to the wage level. And so, my statute and regulation, certain positions are defined as professional. Engineers, teachers, there's a list, but that list is not all inclusive. And so for the positions where that is not specifically specified, we're seeing the government say, well, you have this position that's not listed and it's a level 1. Is this really, it's an entry-level position. Does it really require a bachelor's degree? I think the computer programmer is a really good example. Maybe, a level 3 or a level 4, or someone who's doing really advanced computer programming, that might be a position that requires a degree. But does the, entry-level computer programmer really need one? Well, I think it depends on the very specific position being offered, but that's, something that's going to need to be articulated to the government and needs to be explained in a way that helps overcome that hurdle. Just using basic, information, cookie cutter job descriptions, things like this, it's going to be difficult to overcome.
Right. So it's important to, pre-plan these applications, but if you don't, then the more intricate issues that the Immigration Service raises, the more complex the attorney's research is going to be involved in finding the different case laws that refute the government's positions, and it's going to get more and more complicated to get those RFEs responded to successfully.
Yeah, no, absolutely. And I think it's really a shift from how the government's operated in the past. When we were talking about employer obligations during the first part of the presentation, a lot of the enforcement in the past was by the Department of Labor, and that was done by work site audits where they were looking to issue fines and to enforce back wage liability. Now we're seeing USCIS, who traditionally is, the agency responsible for giving out benefits, also looking at a lot of these issues. And by doing that, the shift is focusing to whether the person is eligible at the outset. And so that means there's a much higher likelihood that there's going to be an issue raised because USCIS is adjudicating every case. Not every employer previously had a work site visit. So I think that segues well into the prevailing wage issues. We're seeing the government looking, or USCIS specifically, looking at the LCA that's been submitted by the employer and the job description and making a decision as whether or not those two things match up in their mind. Previously, this is something that really would have been more in the realm of the Department of Labor, but again, we're seeing USCIS take a look at this. And what they're doing is they're applying the Department of Labor's guidance. There's essentially a mathematical formula that needs to be followed to determine what the appropriate prevailing wage is. And the USCIS will take a look at the job duties, and if you're saying that this is an entry-level position that requires close supervision, doesn't have any supervisory duties, these types of things, but the job duties in your job description indicate otherwise, then we may have an issue. They'll essentially say the prevailing wage on the LCA doesn't correspond with the position that you filed with the H-1B petition and deny the case. So what do we do about these issues? We anticipate these same issues are going to be raised during the upcoming H-1B season. This has kind of been added to the government's repertoire of issues that are coming up. And the best thing that we can do is draft job descriptions with immigration requirements in mind. So that means a thorough review of the job duties for potential pitfalls, being aware of buzzwords that can lead the immigration officer to think that a higher wage level may be required, and also calculating the correct wage, I think, is really key and crucial. This is something that I think has been glossed over in the past by other law firms and companies who have filed H-1Bs, and they were essentially running the risk that the Department of Labor would not audit them. But now every case they're looking at, was the prevailing wage calculated correctly? And so it's important that that be done properly at the outset, and that the employer have the correct supporting documentation for that prevailing wage. It's also important to select the appropriate occupational category, and to anticipate which ones the government may say that the position falls under, that may not require a bachelor's degree, so that we can kind of steer them in the right direction. Additionally, I think obtaining a formal prevailing wage determination from the Department of Labor is key and crucial for all H-1B CAP filings moving forward. We know that these wage level issues are going to come up, and so typically employers in the past, to avoid bureaucratic hassle and to maintain a level of flexibility during the process, have selected their own prevailing wage amount. They've essentially gone through the mathematical formula themselves and identified the one that they believe is appropriate. But that leaves the door open for USCIS to come back and challenge this. There is an alternative process available where we can submit documentation to the Department of Labor, where they will issue a formal determination as to the wage that needs to be paid. Now, it's important that this be done carefully so that a wage comes back that is acceptable for the employer. But should USCIS challenge that issue in the future, you can then provide documentation saying, hey, this is not just me saying this. The Department of Labor, the people who are supposed to be the experts in this area, agree with me. And we found that to be a successful strategy. But to employ it to its fullest extent really requires close guidance from legal counsel about calculating the prevailing wage and making sure that the job requirements line up so that the determination comes back with an acceptable wage.
Right, and it's also important to note that the prevailing wage determination for the H-1Bs are currently taking the Department of Labor about 6 weeks to issue out. So it's important to keep that in mind and start discussing the position for the H-1B with the attorneys quickly, so that we have enough time to send out a determination to the Department of Labor. So what we do is the finalized job description, we send it over to the Department of Labor and have them classify the position based on the DOL's occupational list, where they say, yes, this is a level 1 computer programmer, or yes, this is a level 3 computer programmer. Whatever it is, the Department of Labor is arriving at that conclusion by themselves, as opposed to the attorney and the employer picking out the wage level. This process takes about 6 to 8 weeks for the H-1B, so it's important to keep that time frame in mind. So at the very least, we at least have that in time for the RFE response if we don't have it at the outset.
Yeah. And no, I think that's absolutely right. Now, the Department of Labor should be applying the same formula that the employer is applying. So, there is some art in crafting the prevailing wage request, asking for the determination. And I think that that's something that really should be emphasized. Submitting a well-crafted job description both to USCIS and the Department of Labor is going to be key to getting back the appropriate wage. I also think that expectations are, going to be, reevaluated. In the past, H-1B RFEs were common, but now with the increase, like we mentioned a few slides ago, a substantial number of H-1Bs are receiving these RFEs, and so employers should be expecting these and preparing for responding to them from the outset. And that just really means gathering strong supporting documentation, being able to explain the job requirements to the government, and why the applicable prevailing wage is what it is, as well as why the position requires a degree. This means that there also needs to be a certain level of advocacy that the employer is willing to go through. H-1Bs are no longer routine, just getting selected in the lottery, which I think in the past had been, the goal of so many, because people assumed that if you had the bachelor's degree, your case would be approved. You just needed to be selected, but that is not the current immigration environment. And so employers need to be willing to advocate, need to be willing to provide as much supporting documentation as possible to help their H-1B employees get through this process and to get that approval in hand.
And with that, we come to the end of our presentation. So we can now go into the questions. I do know that we received a few questions. I'm trying to get to those right now. But if you need any assistance with a particular case, or if you have any further questions that we're not able to get through in today's session, you can either call James or myself. And we've got our phone numbers and our email addresses listed there. And there's also a lot of information available in our website, which is www.harryg.com.